So hi, we are Silvia and Arturo Escobar from Escobar Homes with Keller Williams, and today we're going to be talking about a very important subject, which is estate planning. And for that we have Stephanie Garces from Garces Law, and she has actually done this with us before, and she just has great information. So we thought it would be great for her to come, and we usually send this out to our community, people who would really could be really benefit from this particular subject. So Stephanie, thank you for accepting our invitation, and we really want you to just go ahead and take the rest of this time. So, and then we'll have a Q&A afterwards, and we'll cut off the recording at that time.
Yeah, so thank you so much for having me. As they mentioned, I'm attorney Stephanie Garces. I own Garces Law. We are a law firm in Palatine, specializing in primarily estate planning, real estate matters, and we also handle some probate matters, which is where people end up or estates end up when there isn't any estate plan, or perhaps there is an issue with an estate. So we do help with that. So today we're going to cover just the most high-level, frequently asked questions in estate planning, why we should consider it, what are some things that we come across, because a lot of this is meant to be thought-provoking. So feel free to, ask me questions at the end. As Silvia said, I'm going to dive right in so we can take a look at what we have today. So first, I wanted to kind of just say, as a background, having an estate plan is something that a lot of people have on their to-do list, or don't think it applies to them. It's one of the two. So I'm sharing my screen to show you basically from beginning to end, what are some of the most common, estate planning questions that I get. So Garces Law, like I said, I'm going to put my information in the chat. We actually do offer services in Spanish and in English. So if anyone's watching and needs, help with that, and we also offer it in different languages. When it comes to estate planning, though, we talk about estate planning as kind of like a catch-all phrase to include everyone's estate planning is a little bit different, but it's a catch-all to say a will, a trust, power of attorney, depending on what you need, is what's called estate planning. So one of the most common questions I get is, what is a will versus a trust? Well, the biggest difference is that a will is actually a document that is for peace of mind, that it says, hey, I've put in here who's in charge of my estate, who gets what, and who gets my jewelry, what are my wishes when it comes to anything from sharing sharing what I have with my loved ones, who would be in charge of making these decisions, making my distributions go the way I want. The thing that the will does not do, though, it does not actually transfer property. So it doesn't actually make beneficiaries to property as one would think. That's the biggest misconception, I would say. A lot of people think that a will is sufficient to cover your home. And in Illinois, it is not. So a lot of what I talk about today is not meant for legal advice. It's more just to say what the difference are so people can understand what our job is. And so with a will, it's always good to have one, regardless of what you own. A lot of people think I don't have enough for a will, or perhaps I have, almost too little that I would even need one. Everyone anyone has an estate. So the will is great because it is a peace of mind document that helps specify some of your wishes. And if you have minor children, it also allows you to pick guardians in the event of you and your partner's passing, or both parents of the children have passed. You get to kind of pick who to raise them. And it really helps with having the kids have a legal guardian. And if they have to be it becomes more of like a legal guardianship case, there is already a stipulation as to who would raise them that you've chosen. So there's a lot of power that you get back as a parent putting that into your will. The trust is more of a topic that a little more complicated because it actually has a lot more provisions than a will. It has more value than a will. The trust is the mechanism a lot of people use. It's called the living trust, actually, when it comes to properties. So Silvia and Arturo work a lot with people that are buying and selling properties. And so when we talk about trust, we're really considering who would this home go to um, in the event of your passing, or if you have an incapacity. Having incapacity planning is something that a trust does allow, not just what happens if I pass, who gets this house. There's a lot bigger pictures with the trust. The will and the trust are both highly customized to your plans and to your wishes. Everybody has different wishes. Everybody has different scenarios and family dynamics. So whether you are a single person, married person, blended family, divorced, divorcee, there are so many ways to customize your estate plan. So that's really the biggest difference. The trust just has a lot more value, a lot more provisions, and it actually lives with you. So as soon as you sign it, it's valid and it can be used. Whereas a will is used once you're passed, but it gives you peace of mind. What is another common question is, what is a power of attorney or healthcare directive? These documents are basically documents that allow someone else to make your medical or your financial decisions in the event you are passed away. There are also healthcare directives that we offer that do tell a doctor or a person in charge what you would want to happen in the event of your incapacity, or if you have a terminal illness and you can't make your own decisions or something like that, or if you're in a vegetative state. This is something that I always recommend everybody have who's 18 or older. So if you're watching this and you're thinking about yourself and saying, no, I'm too young for that or something like that, everyone should have one, because no one has a legal right to just make decisions on your behalf, not even your partner, your spouse, your kids, your neighbor, nobody. And the other thing is that we get asked a lot is, who do I trust to manage my property and assets and pay my bills if I become disabled? Making these decisions is a big one. We actually do not always know the answer to this because we don't know your family as much as you do. But you certainly want to pick somebody who's responsible and able to help with these decisions and carry out your wishes. What are the powers my agent should have under the power of a property for appointment? And that are not covered by law. So there's a lot of powers you can grant an agent under the powers of attorney, actually. So there's almost so many that it's hard to list them off, but everything that you would want from A to Z of helping you with your stocks, selling your house, having access to bank accounts, investing in retirement, creating other trusts that need to be created. There's a lot of powers that you can give an agent who's the person in charge of your affairs if you become incapacitated. All of that, again, is customized to your situation. And so depending on your wishes and actually what you are trying to achieve if you become incapacitated, that is something that the documents do allow. So there is a lot of powers that we can allow with these documents, but it just is a case-by-case basis. Another thing that we get asked a lot is, should I have a buy or sell agreement with my business partner or succession for a family business? Well, businesses have interest and they're actually really important. Businesses tend to have interests that could be conveyed to a family member or someone else in the event you pass away. There are specific documents and a whole different plan that you can put in place for a family business or for your business partner in the event of your death. So there's a lot of, it's a whole conversation for another day, but there actually is a lot of planning that can go into businesses. Some more common questions that we get with regards to an estate plan is, who should get my money and property when I die? A lot of people will put minor children as beneficiaries of money and property, something we do not recommend because they're minors, so they can't act by themselves. So it becomes very complicated. Who gets the money and property is something you can stipulate to in the documents and put parameters around them. But basically you want to put someone in charge of distributing and managing those money. So definitely someone who you'd pick would be responsible. They'd be good with money. They'd be someone that could carry it out and not actually take the money and go on vacation with it, right? So you want to pick somebody that you know is going to do well. The other question we get a lot is, how can I prevent my minor children from receiving their entire inheritance at 18? Now, some people don't even have children, so this may not be applicable to you, but let's just pretend that you do have children for a second. You could always prevent a minor child from receiving their inheritance at 18. 18 is a very interesting time in everybody's life, right? Like we can all remember when we were 18. you probably were not very responsible with money, like the next 18-year-old. So you don't necessarily want to just leave all your inheritance to an 18-year-old that's going to go buy a Corvette, right? There are ways to postpone the inheritances by putting in different clauses in the estate plan, specifically as to when they get it, how they get it, who's in charge of giving it to them, what can it be used for. I mean, you could get very specific. We've had people even say, I'll only give you X amount if you go seek higher education, right? Or I'll only give you X amount if you end up getting married later in life. There are things like that that come into play. And it's your money, so you could do whatever you want. So there is no rule against it, but it is a lot of things to think about, and there's ways to customize those. Speaking of children, well, and by the way, before I continue in the children's topic, if you are a person that does not have children, you can still put parameters around who gets your money and when. There are plenty of people that leave their money to their best friend, to their goddaughter, their grandson. There are a lot of parameters you can put. Some of them are more strict than others, so you certainly want to think about that. We've had people do things like say, I'll only give you this money if you go, into the military. Well, it's a pretty specific clause, isn't it? So you can basically make it as customized as possible, especially if it's someone that is not your child. So you don't necessarily need to have children to have an estate plan. A single person can be just as hardworking and have a lot of money in their lifetime and have no one to leave it to. Those are the hardest ones to do because you do have to consider who you would give it to and how can you make sure that that person uses it in the way that you want. One of the things that it's not in here, but worth noting is single or married, it doesn't really matter your marital status. A lot of people do leave money to charities. So if you have a charity that is near and dear to your heart, people do make charitable contributions upon their passing as well. Very common. I've had people leave things to non-for-profits, to churches. You can even leave things for your pet. Yes, I said it, your pet. People can create what's called a pet trust, which is a whole nother conversation and a fun one. But you can really leave your money in different ways, not just to people. You could also leave it for your furry friends or perhaps a charitable place. Now, back to the children's part, or even people that you've chosen, not just children. What if the person that you're thinking of leaving your inheritance to has a health condition, addiction, or some sort of spending habits that you're not really sure if the distribution would be a problematic one? Well, there are ways to customize, like I said, the entire estate plan and considerations you may think about. We've had people say, I'm only going to give this to my son or my daughter if they pass a drug test, because perhaps you've had addiction issues that you've seen with your children, or perhaps with the person you're thinking of leaving it to. These are things that are really considered because we don't know what can happen when you're gone. And so I always tell people that estate planning is a way to govern from the grave. That's what they call it, the governing from the grave. We are passed away, but you're still governing somehow, right? So that's the power of estate planning. You're governing from the grave. It's crazy. That's why I think this is an interesting topic. But there's a lot of ways to put clauses to kind of help you eliminate the possibility of the money ending up in the wrong hands and unintended consequences, of course. Can I pick who raises my children if something happens to me is also a very common question that comes up. Absolutely. We talked about the will a lot, having clauses of guardianships. Some people will say they're not too sure as to who would raise the children, and they've wondered if they have to be in in agreement with their spouse about this topic. No, you do not have to be in agreement with your spouse. It is your estate plan. You can pick whoever you want. If you are not with your partner and you still have children, there's other considerations to talk about as well when it comes to that. But you could certainly pick who raises the kids in the way that you would want. Same with your furry friends. If you have pets and you want to leave your pet to somebody, that is certainly something you want to put into your estate plan so that they don't end up without an owner if something happens to you. Everybody loves their pets, so this is a real thing. The other question we get a lot is, who should manage and administer my estate when I die? It's a good question because this is a hard one. It really depends on your situation. Some people have a really close relationship with their siblings and feel that that might be the best person. Some people will pick their parents, but sometimes picking your parents doesn't make a ton of sense if your parents are at an age that maybe it makes them I don't know, more likely to pass before you. Those are things that we think about when you think about who's going to manage and administer your estate. You also can pick more than one person. You don't have to only pick one. There is ways to set it up so that you pick the primary person, and for some reason they can't or not available or they don't want to act, you can put a second person as a backup. Same with incapacity. You can put incapacity clauses that say the same thing. Who would be in charge of your affairs in your incapacity? So you can pick one person, you can pick two people at the same time, although there is implications to doing that. You never know if the two people you've picked at the same time, although your intentions were good, maybe they're not going to get along. These are things and considerations that we talk about with estate planning. So estate planning can be quite boring for most people, but I can tell you it is extremely important for everyone to take this off their to-do list. And for the people that showed up here, at least you have showed up, which is half the battle. But leaving this on your to-do list is not a good idea because, as you probably know, as attorneys, we can only work with people that have capacity. So, if you have you ever seen excuse me, if you ever seen somebody kind of decline in health rapidly, we're not able to represent someone that has an issue where they can't really make their own decisions and then they want an estate plan, because we can't work with someone that lacks capacity or is having issues with competency. So there is some legal requirements and ethics that we run into, which is why I say you don't want to wait. So those are really the common questions that we come across in estate planning. Nothing really out of the ordinary for me, but perhaps thought-provoking for you. And if you have any questions, we're certainly going to put that in the chat, my phone number, and we're offering a 30-minute consultation for anyone that attended today. So does anyone have any questions about what I just went through?
Okay, sorry. Stephanie, thank you for that rundown. I think I've been hearing a lot about like land